We are blessed, honored to have you here. Sir is an erudite in the field of law. He's a jurist, he's a scholar, and he's a living example. Like we say, the Constitution is a living document. But MP Singh, sir, we can also, say the same thing. Sir has been an inspiration for young academicians like us. Sir, a very, very warm welcome to you, sir. And I request all my friends here to give you a big round of applause.
Thank you. So, Chanchal, do we start? Where is Chanchal?
Yes, sir. Sir, he'll be joining shortly, sir.
Okay. So I'll start only after he comes. Sorry, I could not personally come for the program. The reason is primarily some health issues which have recently arisen and have made me suddenly an old man. But in any case, that 82 plus, a man should be old man. That's in any case the case. Where is the again? I'm waiting for him. Let him come.
Sir, just some time back, we also had Excellent Singh sir here. And I must say, two of you are an inspiration, and the zeal with which you're continuing your contribution in the fields of academic will be with us, and we'll keep inspiring ourselves from that. For my participants here, the topic for the discussion also will be deliberating on the demands of common law and its impact on legal pluralism.
Right.
Sir, good morning, sir.
Good morning.
Sir, your video is off.
Yes.
Sir, could you please switch on the video?
There is security video.
Sir, on the bottom side, there is a tab called switch on video. Stop.
Start video. Video is already there. So, what I have to do more?
Yes, sir. We got it. You are visible perfectly. Can you see us, sir?
Okay, thank you. So, namaskar. So, perhaps you have told about the topic on which I am expected to speak, and their concept, the title of this paper, which has not yet been actually published. I had lost it, but then suddenly the other day I found a copy of it somewhere. So this is on the concept of justice in India and legal, historical, and social perspective. So basically, my thesis is that concept of justice actually is not discussed in Indian literature until at the time of the constitution making. The justice was added as the first virtue in the constitution for the purpose of individuals as an individual right, and that virtue actually was divided into three: social, economic, and political. But we are concerned with the general idea of justice, whether it has been discussed by anyone uh, before the constitution was made, or even after the constitution, whether there has been a study of what is justice. And this is so therefore the beginning is to be made with Chhatrapati Singh's Law and Anarchy to Utopia. And Chhatrapati Singh actually says, uh, let me tell you in short from the very beginning, and that is that what I am going to say. My idea is that the concept of justice was never developed in India except after the commencement of the constitution. So any discussions on the concept of justice are to be found only from constitution onwards. Before that, uh, there was no idea of justice discussed in our literature. The literature which is considered to be part of our beginning, that does not devote much attention to the concept of justice. Now, this is in a way, is a very radical idea, that telling that Indians did not have a concept of justice or did not discuss a concept of justice. But the irrespective of that, I have decided to uh, say that and do some research. For example, uh, P.V. Kane's 6 volumes uh, on history of uh, history of history of yeah, Dharm Shastra, history of Dharm Shastra. So please excuse me, the old age has made me like that. So history of Dharm Shastra in 6 volumes. Nowhere in the index to the book the word justice has been found. Of course, it is a history of Dharma Shastra, but how far Dharma Shastra actually uh, discuss the concept of justice. And the this, I think, is by and large recognized by uh, everyone, but Chhatrapati Singh has to say something which may be different. He says that no society can work without a concept of justice. Now, if we go by his definition of the concept of justice, it it says, just a moment. He has discussed it at several different pages, but I am just telling you the relevant one. And the his statement is, it will be of interest. Earlier he has talked about dharma and all that. It will be of interest to note here that the word justice derives its linguistic roots from the Sanskrit root term yu or yuj, which means to join. The words justice and join thus have the same roots. Yuj becomes use in later Latin, and changes through use to yost in Old French, which retains the meaning of to join. Yukti in Sanskrit means a principle which is instrumental in joining a means to an end, and yojana is a plan to that end. Yoga is basics. Yoga in its basic sense means that which joins man to the transcendent being. uh, Justice as opposed to yoga in its basic sense then means that which joins man to man. So this is what his conclusion is, that the word yoga means joining, and the concept of justice in our shastras is reflected in the idea of that yoga or joining. Now, this, however, is incomplete discussion in the sense that the definition, perhaps in a way, you may say that this definition was not known to everyone or to anyone until Chhatrapati Singh's research on it, and that was a remarkable study on his part of Indian ancient literature, along with Kant and others in the Western world. Now the question is that so this is one proposition which I am saying, that until the making of the constitution, the concept of justice was not discussed in our literature, uh, uh, irrespective of what uh, Chhatrapati Singh says and explains. The the question, however, we have to mention that some of the scholars amongst us have actually tried to find out the concept of justice in the not only in the constitution but in earlier ideas also, and among them perhaps uh, Professor Amartya Sen is the one who has written a book on justice, and in that he has related Niti and Nyaya, and he says that Nyaya is the concept of justice. Actually, uh, Nyaya is not a concept of justice in the sense that the philosophy of Nyaya is a philosophy of logic, basically, that you can prove something or disprove something by logical discussions. So that is what is the purpose. We are said to have discussed things, and that in our ancient times the uh, scholars or saints or whatever you would like to say them, they used to have great discussions in which even ladies used to participate. But those discussions actually are confined to discussions about those ideas which are vague, which an individual cannot face or does not face in day-to-day life. And those ideas were related basically to God. uh, Nobody of us has seen God, what God is, and the other concept apart from God was of Atma, and these two concepts, that particularly this Atma concept, that led to all sorts of discriminations and injustice in the country. It is on that basis that Manu could make the division of fourfold division and create a category of Shudras and Panchamas, that kind of conceptions developed in India. Uh, Amartya Sen has, as I said, tried to mention it in Niti and Nyaya, and I have told you that this is a different concept. Philosophy of Nyaya means our philosophy is divided into 6 schools. Amongst them, the most important is Advait, but the uh, other ones like Niti uh, or Nyaya. Actually, Nyaya is philosophy. Nyaya philosophy actually is concerned with the logical discussions. That something which you can prove or disprove by logic, that is the Nyaya philosophy. But it doesn't actually in any way include the concept of justice within it. You may say that some concept of justice was there, but most of the discussions. So this concept of Atma also uh, gave support to what Manu has written. That we today also we say that if a man dies, his Atma moves to other person or to an animal or anything. But uh, this I feel that has actually created the kind of society which we have and which or we had until the making of the constitution, and which divided us into several groups, because you can say that Atma is there in a pig also, Atma is there in a any insect, and it is also among human beings. But what happens of that Atma, nobody knows actually scientifically. Is there anything like Atma? And uh, I may even say that is there anything like Paramatma? So these concepts of Amartya Sen also fail to clearly lay down a foundation of justice in our Shastras. So the concept of justice actually has developed only in later times, and primarily from the commencement of the constitution, because as I told you in the very beginning, the constitution very specifically actually uh, talks of justice. Yes, let me also say historically, if there was some discussion, it was in Arthashastra and nowhere else. So Arthashastra actually talked of, it says, but in spite of the superior qualities of Arthashastra as a code, it also does not directly throw any light on any concept of justice. Even the theory of karma or being uh, argumentative or deliberating, Indians uh, uh, Indians use no, uh, it's not of any avail. This is what one may say so far as Arthashastra is concerned. And maybe Arthashastra was actually hidden somewhere until in the uh, last century, last to last century, it appeared somewhere. Uh, Otherwise, nobody knew about Arthashastra before that. And even after that, it is not discussed that much, as much the Shastras are discussed. Now, so far as the Constitution of India is concerned, of course, there the concept is mentioned very clearly, not only in the preamble, but also inside also. Uh, and that inside discussion actually justifies a kind of discussion which is similar to what, for example, in the uh, Western world, this Professor, yeah, Rawls, Professor Rawls actually has made two propositions with respect to uh, concept of justice in his book, and he says that there are two principles of justice according to Rawls. First, each person is to have an equal right to the most extensive basic liberty compatible with a similar liberty for others. So, number one is equal liberty to everyone. The second one is social and economic inequalities are to be arranged so that they are both reasonably expected to be to everyone's advantage, and B, attached to positions and offices open to all. So far as the Constitution is concerned, it provides for both the kinds of principles which Rawls has laid down with respect to the concept of justice, and in the sense that fundamental rights are available to everyone. They may be inferior to rights in some other constitutions, but so far as the Indian Constitution is concerned, I think it makes a big difference from the existing or until then existing society in India. uh, Society may have not changed even now, but the second principle also, that some positions are open to everyone, but if, for example, they are not open to everyone, everyone has the right to enter those positions. So even our uh, President of India can also be a Shudra. And we have examples where persons who were considered as Shudra, they have been the presidents, more than one presidents of India. So this kind of discussion actually uh, we never find in our Shastras, to which we refer time and again. Therefore, going in the present scenario by the Shastras actually is doing injustice to the Constitution, which is now foundational of our system. Religious matters may be uh, restricted to religion, but so far as the concept of justice is concerned, that has to be read into the Constitution. Uh, I have cited from certain cases also where this kind of interpretation has been given by the court, uh, and some authors also have said that, for example, uh, developing a thesis of justice as equity since the establishment of imperial rule in 1858. Nithi Mukherjee explains the concept of justice in the preamble to the Constitution as follows. In sharp contrast to Western constitutions based on the category of freedom, anchored either in collective identity or individual property, the Indian Constitution was grounded, as the preamble makes clear, on the category of justice as the sovereign legislative principle. The primacy of justice over freedom was not, however, just a philosophical matter for the framers of the Indian Constitution. They laid out how the category was to be deployed in practice. In very precise terms, in Part 4 of the Constitution, a section called the Directive Principles of State Policy, that was to be the framework of the entire legislative practice of the post-colonial Indian state. What the Directive Principles reveal is the determination of the Indian National Congress to convert its philosophy, as already expressed in the preamble, into a practical guide for legislation in the future. This is what Mukherjee has written, this Miki Mukherjee. And then another scholar also, who has also written on history of, and through that she has tried to actually, Miki Mukherjee is also a lady, and this other lady also, Ananya Vajpayee, she has tried to uh, give the concept of justice by referring to certain personalities that appeared in this country, particularly during the time of the freedom struggle. So she says, this new India, whose key text, the Constitution of 1950, Ambedkar chauffeured into its inaugural form, had to be imagined on the basis of a kind of selfhood that would appeal as much to Hindus as to minorities, to upper castes as to Sudras and untouchables, and to those in the mainstream as to those on the uh, margins, on the margins. And then Supreme Court also in several decisions has talked of social justice. And let me read out one of the, this is a case from 2006, 8 SCC. Some time back, the Supreme Court also notified the constitution of the Social Justice Bench in the following words. Under the domain of social justice, several cases highlighting social issues are included. To mention summarily about the release of surplus food grains lying in stocks for the use of people living in the drought-affected areas, to frame a fresh scheme for public distribution of food grains, to take steps to prevent untimely death of the women and children for want of nutritious food, providing hygienic and midday meal besides issues relating to children, to provide night shelter to destitute and homeless, to provide medical facilities to all the citizens irrespective of their conditions, to provide hygienic drinking water, to provide safety and secured living conditions for the fair gender who are forced in prostitution, etc. These are some of the areas where the constitutional mechanism has to play a provocative role in order to meet the goals of the constitution. Similar thing in Nagraj case, Justice, whoever was the Chief Justice at that time, as I told you that I easily forget the names. So uh, similar things actually had been said earlier by our this uh, constitution by Grenville Austin, and the Grenville Austin, while in his book changed his position to some extent uh, in regard to the conception of justice. And he says the Indians' sense of their rich cultural heritage, their record of professional achievements in the arts and sciences of the modern world, and their faith in their ability to govern themselves, combined to give them a national maturity that allowed a reasoned approach to the creation and working of government, equipped with the basic qualifications, attitudes, and experience for creating and working a democratic constitution. Indians did not default their tryst with destiny. This is quotation from the Independence Day speech of Nehru. So with that, he ends that certain things are happening which are uh, not consistent with the idea of justice. Uh, Bakshi has always been critical of. Uh, so when he first time actually uh, wrote a review of his first book, there also he was very critical of what Granville Austin had said. And when Granville Austin died a few years back, he again, even after his death, was very critical of him. I need not mention that because bad things should not be read out also, should not be said also. Uh, in, uh, so far as the idea of justice is concerned, it is now slowly percolating. This is another quotation. Similarly, taking a few aspects of social justice in the making of the constitution, Samir Kumar Das says, the philosophical debates on justice, therefore, are different from the uh, Constituent Assembly debates. Justice cast in the constitutional mold looks unrecognizably different from what the great philosophers want us to believe. Justice is crafted differently in the enterprise of crafting the Constitution and constituting the social body. The constitutional mirror, we, as we agreed, was after all a magic mirror where realities, in order to be reflected, were to observe all its magical rules and protocols, or else the mirror will crack and there will be a dismembering of the body. So I think with this, there are a number of other things also in the paper which could be said, but I think with this I stop and would like to answer your questions if there are any.
Good afternoon, sir. This is Mrityunjay from Shimla. Thank you for delivering this lecture on idea of justice in ancient and medieval India.
Hmm.
Now I would like to invite questions from the
Yes,
participants.
sure.
Yes. Any question? Sir, I will start with my question.
Yes, please.
Sir, when we talk about dharma and dharma in sense of duty,
Yes.
so when dharma originates the idea of justice in any sense.
No, that is what from the idea of dharma, Chhatrapati Singh has tried to find out the concept of justice, but whether that was in any way proved or disproved, some of these things. For example, uh, on the concept of Atma, we have developed the concept of four varnas or five varnas, whatever it is, that Atma moves from one category to another, and uh, if a person does good things in life, then uh, in the other life he becomes a good person, and if he does bad things, then he is uh, uh, reduced to maybe animals or insects or anything. Now, among the human beings also, that was the foundation or basis for the caste system. And as a result of it, it used to be justified all the time that Shudras are those who have done bad things in previous life. Now, who knows what is Atma and who has seen what is Atma? All these concepts are, I will say, being developed only for the purpose of controlling or regulating certain things at that time. And I was reading one of the books by a Muslim philosopher, professor of philosophy. Long back, he wrote a book, the Shudra, the Shudra, and in that book, basically, he is not critical of everything so far India is concerned. But at the same time, these conceptions which he has made basically towards the end only a discussion on Shudra. And this discussion, in that discussion, he says that the previous writings, that the Dharma Shastra actually, they justified all these on the ground of the kind of works you have done in your past life, and therefore you are suffering. So if you are born in a Shudra family, it is because you had done some bad things in the past life. Now, whether, and therefore you have to suffer in the present life. Now uh, um, I have difficulties in accepting this kind of proposition for which there is no proof of any kind that there is something like Atma or anything. Scientists have been trying to find out whether a person, when he dies, whether there is something inside which moves away from him and takes another form somewhere else. We have to believe it simply because it is our Shastras which say so. This is my explanation to it.
Yes, sir. Sir, Professor Akhil Belgrami, in his book,
Yeah.
trying to establish that in India, the concept of truth was not only an epistemological concept but also a moral concept. So, in that
Mm.
sense, there was no differentiation between knowledge and morality. So,
Yeah.
in that sense, can we say the idea of Nyaya, what Amar is trying to say, the idea of Nyaya is also the reflection of logical deduction at the same time. The purpose of Nyaya was also to facilitate justice.
Uh, No, Nyaya was never used for the purpose of facilitating justice. Only you have to prove logically or disprove logically something. And that was the basically means on the basis of reasons which you give, you have to uh, justify or not justify a particular proposition. And but it doesn't. I don't think that if it has created anything, that is something about Atma Paramatma again, uh, which you can describe in any form, in any way one likes. But what is the scientific proof that there is something like God or there is something like Atma?
Sir, any question? Ayush.
Very good afternoon, sir.
Yes,
This is Ayush. Um, so we have been discussing about dharma, sir.
yes,
In the modern times, so-called modern times, or the contemporary legal administration system, there has emerged a correlationship between duty and rights.
yes,
This topic also talks about looking at the possibilities and challenges of legal pluralism.
yes.
So, in that context, is there any idea that we can derive from the concept of dharma or manifestation of social justice in the contemporary context? So, can you throw some light on that?
Yeah, Dharma actually, Kane has defined it as a duty, not as a right. And therefore, by performing your duties, and that does not in any way affect so far as the caste system is concerned, for example, in India, which is considered to be a kind of uh, really slur on the Hindu society. Is if we go by that, the way people were treated and are still being treated, uh, that is has no clear justification anywhere. So if it was part of duty, you have to perform your duty in whatever form you are born or in whatever family you are born, and accordingly the kind of things you have to do in that life, they are also specified what you can do and what you cannot do.
So we are also talking about story collection of Vikram Betahu. And in that story collections, there are so many stories related to the king, how to do justice in a particular context. Though it was fictional in character, but those
Yeah.
stories were trying to reflect on this question that how kings should decide a case so as to do justice with the parties.
Yeah, that I don't think that the uh, uh, dharma did not play any role in that. The concept of dharma actually played that role, and accordingly, uh, uh, punishments were assigned according to the caste to which you belong, because you have done some wrong things in the last birth. Therefore, you are born as a part of a criminal gang or as a Shudra or whatever it is. So, this is how I would try to interpret it.
Any other question? Neha, please.
Good afternoon, sir. My
Yes.
question is, how do we justify excessive criticism of certain aspects of Indian literature, especially ancient and medieval, for instance, Manusmriti, vis-a-vis, say, criticism of Aristotle's work of good life? When he's talking about good life, he said exclusion of slaves, exclusion of women. So if you
Yes.
look from that context, even Manusmriti has
Right, right. But Buddhism with Bud okay, you finish. You finish first. Okay.
how
Uh,
to justify excessive criticism of our literature vis-a-vis, say, Western literature, firstly. Secondly, how do we then change that scenario now that as legal researchers, as Indians for that matter, how do
yes.
we make sure that our literature receives a due credit?
So I don't think that much support can be taken from Shastras. Therefore, you have to read the Constitution in the modern context, and the persons who made it, whether they were all enlightened persons. Maybe some of them were not that enlightened as Ambedkar or Nehru or others. Uh, but even then, these were the people who were in majority in making the constitution, and so the constitution was framed on their ideas. But so far as the earlier part of our life is concerned, perhaps you were also mentioning Buddhism. Uh, Actually, that is what I am saying, that the at that time uh, these uh, uh, those who wrote the literature, particularly Brahman, the literature which is called Brahman. Uh, the Brahman literature basically, first time actually, Vedas don't have any description of any caste or any community or anything. It's only in Brahmins that the idea of caste system and all this was developed, and then it was strengthened later on by Manu, by giving a detailed description of that or a systematic description of that. But Manu, how far it is acceptable today, I'm not quite sure, and whether it is desirable to accept him as the final author of this. And that is why, as you said about Buddhism, Buddhism did not stay in this country only because this class division, uh, because Buddha did not recognize caste division, and even a Shudra could become a member of the Sangh. And so far as the dominant class here was concerned, similarly, Jain also, Mahavir Jain also did not believe in these caste system and all that, and therefore anybody could become a Jain also. It is another matter that Jain community is now rich people. Uh, some of them may be intellectuals also, but so far as Buddhists are concerned, they are not even rich persons. But some of them is still, even Ambedkar towards the end of his life had converted into Buddhism. Uh, but Buddhism is not a dominant religion existing in this country. But there are countries where Buddhism exists. Uh, the largest religion which is prevailing in the world is Buddhism, and therefore the whole of east of us, uh, all the systems, they are actually followers of Buddhism, and they have some understanding of what Shakyamuni they call as Shakyamuni, that some idea of what Shakyamuni actually said, and whether all things were logical from by Shakyamuni, or some of them were illogical too. These discussions are actually carried on among the people. So, and I am telling this because a very serious uh, girl student from China, when I was teaching for a semester in Singapore University, uh, she raised this question similar to yours, that we follow Shakya Muni's uh, uh, right, whatever principles he laid down, but we are not satisfied with some of the things she was saying, that only stay in Sangh and all that. But these were not the Sangh he made, because the rest of India uh, was different from Sangh, and in Sangh, even the Shudras actually were made members. It is another matter that later on, because of some problems inside Sangh, as well as because of the opposition of the Brahmins in this country, Buddhism could not flourish so far as this country is concerned. Uh, uh, I'm not able to hear you. I'm not able to. Yeah.
Am I audible?
Yes. Now you are.
So, sir, without the institutional propriety, the concept of Nyaya could be reduced to the level of much Nyaya. How do you think that the institutional propriety could be maintained in our country?
Uh, Institutional propriety, which kind of institutions actually you are talking of?
So, if we take judiciary as an institution,
Yes.
what is the necessary thing that that propriety could be
Yeah.
maintained?
Yes. Yes. No. Of course, there may be judges are also human beings, and they are also capable of doing mistakes, and therefore some judges may at some point make remarks, which remarks actually are may not be justified in a particular case. That may be the position in regard to judges. But it was the Chief Justice at that time who wrote the opinion in Nagaraj case, and supported the idea of justice in the constitution. He is not saying what was the position before the constitution, but definitely he is saying that what the constitution has done.
Okay. Next question. Okay, that's it.
So my question is, for the legislator has come across to ensure. So my question is, how far the legislative have ensured and strengthened the social justice after independence in our country?
Yeah, so far as independence is concerned, firstly, universal suffrage was the most important thing which they did in a country where maybe more than 50% people were illiterate. That was a remarkable step on their part. And then they also ensured that so far as these weaker sections are concerned, they are also represented in our parliament and decision-making bodies. Uh, the the only thing is that there are some disputes with respect to who among the women, for example, be members of the parliament or of a state legislature. And no agreement has been reached so far. But so far as the later development in the constitution took place, and this is particularly Panchayati Raj system. There we find these new chapters in 92, 93 were added articles, not chapters, but it is number of articles. So it is done there that women will also be in a particular proportion so far as the members of the executive of those bodies are concerned. So it is not that the if we look at that, so far as the constitution makers are concerned, they are moving in that direction. There may have been some difficulties in actually implementing those directions, but they have moved in that directions, and not only for women but also for the those communities which of course were protected under the constitution also. They have also to be accepted and acknowledged as administrators or judicial decision makers in the panchayat system.
Any other question?
Yes, please.
Sir, only final question. I would like to. Yes, only question.
So how far you think reservation is a tool, effective tool in ensuring the social justice?
What what are the difficulties in achieving the concept of social justice? I think first we have to understand that now Shastras are not our social justice. Our social justice is now the constitution. And therefore, people have to be given equal respect, men, women, everyone. Simply because somebody by accident is born in a particular family, uh, it does not mean that he by birth is a bad person. Uh, uh, people are born in good families as well as, but who is good and who is bad, this you cannot fix forever, which we have fixed or Manu has fixed actually forever in our system.
Sir, one final question, sir.
Ah,
When we talk about Homo erectus, or the caste or categories in constitutional sense, are we able to eliminate that menace from our society, even though constitution and constitutional justice is there?
ah.
Though we say Manusmriti is bad per se because of caste system, But our constitution is not able to promote distributive justice, which is supposed to be under Article 39 BC.
Yes.
Since class character of our society resonates similar kind of idea,
Yes, yes.
and that's
Yeah,
why justice, Manu justice, both appears to
right.
be on that plane.
Right. I entirely agree with you. So therefore, I need not say much. That even constitution is not being followed. It is being followed in its violation, and therefore this kind of arrangements are being made under the constitution. Even Brahmins now have reservation of 10%, just like Harijans have. So this is. I was actually
मृत्युंजय,
hoping.
कैन यू हियर मी मृत्युंजय?
ये मृत्युंजय है क्या?
सर मैं चंचल बोल रहा हूँ. दिस इज चंचल.
नहीं, मृत्युंजय था जो सवाल पूछ रहा था.
This was Mrityunjay. Sir, I have 2-3 doubts and 2-3 comments also. Kindly allow me to raise these doubts and questions in the second session at 2 p.m. दूसरे वाले क्लास में. Mrityunjay, can you repeat it?
Sir is asking, sir, that sir has few doubts and comments, so he would like to make it after lunch, I think.
After lunch, sir. It's the second session. I'm just noting it down, sir.
मुझे थोड़ा आसान हो जाएगा, फिर सेकंड लेक्चर के लिए कुछ और तैयार करने की जरूरत नहीं है. इसमें ही वक्त.
Sir, first doubt, sir, I'm just pointing out the first doubt as one of our participants pointed out. Even in the ancient Western traditions of philosophy, Roman or Greek, justice was seen not as a propriety or at the level of institution, but at the level of individual and society. So social, we can call it rather rule than value, or principle than other than more than principle. It was a value. So if we look at Rawls, Rawls says that these two principles are applicable not to the individual, but to the basic structure of society, that is institutions. They are bound by these two principles. They are going to administer, implement the two fundamental principles. Rawls have arrived in a contractarian method. So if we take this distinction even in the West, and then we go back in ancient or medieval Indian traditions, there can be, I believe, found out many principles or practices that might be developed at a different kind of, because we don't have to talk in Western epistemology or terminology. Because of that terminology, the result will directly carry that there was no conception of justice in ancient India. So we have to come out of that structure of thinking, and then to look at. But this is a very difficult task. Apart from text and practices, historicity has to be determined. So that was my one of the doubts, sir.
Yeah, no, your doubts are actually fully justified in the sense that so far as any society is concerned, I don't think that there is a full equality, and the interests of everyone are being taken into account. But a society which actually justifies on the basis of karma theory or something, that merely because you are born in a particular family, therefore you have to suffer this. Now that kind of thing did not exist so far as Western world is concerned. Of course, there has been slavery. For example, Aristotle was the first person who in Western society spoke of equality and justice. And he said simple definition that justice requires that equals should be treated equally and unequals should be treated differently. Now, this was his proposition with respect to the concept of equality. But at the same time, he justified slavery by drawing a distinction between citizens and slaves. And therefore, I am not saying that injustices are not happening in those societies also. So they have been happening, and that is why, therefore, persons like Rawls, for example, are developing the principles. And his subsequent writings, apart from this book, again and again he is emphasizing that propositions which are uh, justified in all situations, they should be accepted by everyone. And that is what basically his conception is. But I know that you are a teacher of jurisprudence, therefore you may ask tough questions which I did not answer properly. But feel free. तो तुम लोग अब कब मिलेंगे?
Thank you, sir. Next session will start.
Sir, next session at 2 p.m. sir, after lunch.
अच्छा,
जी sir.
और मेरा तो लंच बनता भी नहीं है 2 PM तक, तो उसके बाद ही मैं तो खाऊंगा तुम्हारी बात करने के बाद.
Sir, we will try to keep it, sir, as interactive session. So that will be good, sir.
Okay, okay. So it would be a sort of continuation of the same thing?
Yes, sir. Yes, sir. Yes.
Okay, okay. Then it is fine.
Legal program.
Then it is.
Thank you
Yes,
so
yes.
much, sir.
Thank you. Thank you.
Thank you.
So for the moment we switch off the.
Right, sir. You can. Yes.
Okay.
Ayush, gather everyone in the canteen itself. We all will have lunch in canteen itself today, right?
Yes.
Ayush?
Meeting.
One. Thank you, sir.
Thank you, sir.
Okay.